Giovanni, you've also worked on tokenized assets and digital assets. And so maybe that's a good segue into the regulatory challenge we're also seeing at the moment on that space. How do we address the compatibility of the digital asset and the traditional ones? Is there anything you can give us your input on?
Digital assets and traditional assets, there's been already quite a lot of studies regarding the nature of digital assets and how they can be taken further. Here in the UK, we already have a law proposition for what will be the legal status of these digital assets, simply because they're not just plain records. They can actually have their own weight and their own rights in terms of embed economic rights, which they need to be effectively identified. Digital assets, the way that the regulation has been working is that so far, if in financial services, if they look like something that already exists, such as securities regulation, so a token that behaves or references an asset, very similarly to what you would have with a security referencing another asset, by default, they fall under the rules of existing rules of securities law. And this is something that it can be observed pretty much anywhere in the world, including the US, including in large centers in Asia, Singapore, Hong Kong. It's very clear that that's the case, or that's how the regulators have interpreted that. The new rules are all aiming both, for example, in Europe with MiCA, which is a fairly common piece of regulation, and others here in the UK. There are other examples. They're all aimed to basically regulate what is not interpreted as a security token. And so when the asset is referenced something different or something new. And in that specific case, you have to make a distinction between that being a token or that being a token that is referencing a currency, for example, or is that referencing something new? So making a distinction usually between stable coins and assets in general. So cryptocurrencies, for example, which are technically tokens referencing something new, those have very specific treatment. And so Bitcoin in itself, is legal status of Bitcoin is now becoming that of an asset like many others, but the reference effectively has already been created in the regulatory space so that stable coins are isolated in terms of legal status than, let's say, cryptocurrencies. The system that is emerging is therefore one in which some governments are taking the lead on understanding or at least promoting what digital assets can be as valuable and as fruitful as any other asset or form of registration. The regulators are already taking quite a lot of steps into issuing digital asset regulations with the methodology which I described, distinguishing securities from other types, and then further dividing stable coins from other type of crypto assets. And then even the international standard setting bodies has already set up international standards, so we can expect that this type of framework is going to be the one adopted pretty much everywhere in the world.
No, that's very interesting because it seems that at the moment the two are evolving in almost like in parallel. We're using whatever is existing from a regulatory perspective on traditional assets, trying to encompass those new digital assets. And really, the key challenge is going to be to try to combine the two without stifling the innovation, because we also want to make sure, as the market is evolving, that innovation is still there, right? And that's always that fine line for regulation to be here to give a safe space for participants, but also still allow for innovation